On to this story now. The Zondo Commission into state capture wants the Constitutional Court to compel the former President Jacob Zuma to appear before the Commission and to give evidence. Now, this follows Zuma's decision to walk out of the Commission of Inquiry and his letter to the chairperson, the Deputy Chief Justice Raymond Zondo, indicating that he will no longer be participating in these proceedings. Well, this morning, the court heard arguments by the Zondo Commission's legal representative, Adv Thembeka Ngcukaitobi. Let's discuss the outcomes now of these proceedings with our politics editor, Sbu Ngalwa, who talks to us all the way from East London. Sbu, a very good afternoon to you. Firstly, let's begin with the arguments that were advanced by the Commission of Inquiry into state capture. The legal representative there, Advocate Thembeka Ngcukaitobi, what did he have to tell the court?
I think, Toli, the important thing here is that there were two main arguments that were before the commission. One was the issue of urgency, which is what the commission had requested. It brought the matter to be heard on an urgent basis, but also there was the issue of direct access, where it sought direct access to the Constitutional Court. Now, just to track back a bit, as you rightfully said, this had to do with Zuma walking out of the commission, and the commission wants the court to force Zuma to appear for the commission. Now, the argument here by Ngcukaitobi actually had a tough time trying to convince the judges on those two key points, starting with the issue of urgency. The one question which the majority of the judges kept asking was, why did it take so long for the commission, after it had issued a summons in January, for them to finally compel Zuma to give evidence around August? And the argument there from Ngcukaitobi was that, well, there was a 3-month lockdown, but also Judge Zondo wanted to be as conciliatory as possible in trying to convince Zuma to appear, as opposed to taking an aggressive aggressive approach. But it looked like the judges had a problem with that. In fact, Judge Matanga and Judge Matopo, including Justice Kafka, did say to Advocate Ngcukaitobi that it appears that this urgency, in their words, is a self-imposed or self-created urgency, because they feel that the judge, Deputy Chief Justice Zondo, now feels that his time is running out and is now running straight to the Constitutional Court and using the argument of urgency. The second issue of direct access stems from the following: that Jacob Zuma refused to appear before the commission. He said he no longer participate. Now, the justices wanted to find out why the commission comes straight to the Constitutional Court when they could have gone to the High Court, and the High Court could have given them the same relief that they seek. And it goes back to the issue of urgency, where Advocate Ngcukaitobi, actually by his own admission, says that, look, the reality is that if we went the route of the High Court, and then the High Court found in our favor, that is the commission, that could still have been appealed, and that would have taken a year. The SCA in Bloemfontein, the Supreme Court of Appeals, but also from the Supreme Court of Appeals to the Constitutional Court, take another year. But the justices were not even convinced by that, because they said that given the urgency of the matter and the gravity of the matter, the High Court could have still given them, had this thing urgently, and so would the SCA. So it didn't look like they were quite convinced by some of the arguments there, Claudia. So those are some of the key issues that came here. And I think one important point before you come in here is that was the issue of that relates to, because remember, the commission is saying that the court must go as far as forcing Zuma to give evidence, and that Zuma cannot hide behind the right to remain silent or the privilege of him not further incriminating himself. And there were a number of questions that came from the different justices, Justice Khabembe and Justice Shiki being one of them, saying that, but hold on, isn't it a constitutional right for someone to exercise their right to remain silent? Remember that the former SAA chairperson used that privilege when she had to give evidence, where every other response that she gave was motivated by, I cannot give a response, Chairperson, lest I incriminate myself.
Yeah.
So what the Commission is arguing is that you cannot use that argument here. So it looks like it will be an interesting outcome. I'm not a legal person, but I think that judgment, when it comes out, would be interesting in further clarifying what happens going forward, Claudia.
What about the counter argument, Sbu, from former President Jacob Zuma's side, and who was arguing on his behalf?
No, remember the former President Jacob Zuma first told the Commission that he will not further participate, he's not interested in those proceedings. The same has happened here with the Constitutional Court. In fact, Advocate Ngcukaitobi even went as far as making the point that the contempt, he argued that Zuma has been in contempt of court, but also has also been an interesting witness and a hostile one. He even says that that disrespect even extends to the Constitutional Court, trying to convince the judges that the disdain which he accuses former President Zuma of also extends to that court, because he also has not opposed that application to the Constitutional Court, which actually is an attitude that says whatever happens, happens, basically.
Yeah, it's going to make for an interesting outcome. Sbu Ngalwa talking to us about the outcomes of the arguments at the Constitutional Court resulting from the walkout of the former President Jacob Zuma